Mr. Mr. Williams, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 9 days in jail with credit for the 19 days that you've done. I want you to understand that this behavior is just
Here's the
unacceptable.
deal. This isn't just about punishing one guy. The judge is making it crystal clear. If the court goes soft, it sends a signal that nobody has to take the law seriously. Question for you. Do you think judges should hammer down harder on first offenses or give people more second chances?
Serious when I mean that here we're about accountability. And if I don't hold you accountable, I'm telling you it's okay and that you can just continue to run amok and just railroad. And it's not. We mean business. We're here to not only protect the community, but teach you a lesson so that you understand that it can't continue. Right? I don't know what happened over there. I don't need, but when you're on bond, you can't pick up felony. And there are consequences, and I hope that you get it. Right? The other thing that you need to get also now is that this will reflect as a conviction on your record. If you're ever in a car, I don't care where you are, I don't care what state you're in, you get pulled over and you have a smell of anything funky, they're going to probably take you in. They see that you have a prior DWI, if it walks like a duck and it talks like a duck. So if I were you, I would never, ever get into a car, even if you've had a sip of alcohol, hook off of a joint, you smell anything funky, I'm telling you, you're going to go down. And what we're doing today, from now on, you're facing a minimum of 30 days in jail. So, like I'm saying, I'm doing this, believe it or not, to help you. Because we want to see the best in you. We want the best from you. Be better. Do better. You know, you're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. It will go on your record. You'll be there forever. I have to suspend your license. I'm going to suspend it for 180 days. There is also a mandatory suspension, a DPS surcharge. I will waive that for you now. But I want you to understand that if you come back, second offense, you're looking at a minimum of $1,000 in fines and fees, not to mention another court cost of around $700. So you pick up another DWI, not only is the minimum 30 days, but you're looking at probably around $7,000 in fines and fees. One button on this phone, $30. Wherever you want to go in this, don't matter where you want to go. How do you plead to the offense? Guilty or not guilty? I'll find you guilty. I will sentence you to it. You're going to walk out of here. You're not going to owe anything. Don't come back. All right. Thank you, counsel. All right, guys. Look. Yes,
This is Brian Martinez, Judge.
come up. Hey. Hey, Steven, that dude in the blue jacket. Grab homeboy. Did he just now get here?
You got here probably about maybe 15, 20 minutes ago.
I don't know what I'm going to do with you. All I know is I want the truth. I want you to raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I haven't decided what I'm going to do with you, but I want truth. And if I think that you're lying to me, I will revoke your bond and I'm going to put you in jail. Do you understand? If you're honest with me, it will go a long way. I promise you. Why did we have tamper?
La verdad no tengo idea qué pasa. Yo he estado portándome bien, I've been behaving, trabajando, working, y no he hecho nada más que concentrarme en eso.
I've only been
Portarme
focusing on
bien, no he tomado
Where
más alcohol.
behave properly. I have not drank more alcohol.
To know about tamper and whether you put something in your leg or not. Be
Yeah.
honest, Mr. Martinez.
No puse nada. Lo que sí a lo mejor pudo haber pasado cuando le fui a cambiar la batería. Bueno, hice un reemplazo de batería.
Like what could have happened, I didn't put anything in there. What could have happened is whenever I changed the battery, I've done it once already.
Keep it down, please. You did what?
They had contacted him to have him change the battery. And I don't know when that was, in that time frame. But what he had also told me is that he trabaja como pintor.
Yeah, painting, I do walls, sanding, I do flooring.
So I don't give a rat's what you do in this life. I want to know what happened with tamper because they're telling me the device lost contact with your skin.
That's what
All I'm asking for is the truth.
That's what he's trying to
Truth
explain.
shall set you free.
No he cometido eso. Bloquearlo, no lo he hecho.
I haven't done that. I haven't blocked it.
Puede ser el polvo que quede en mi trabajo, puede ser otra cosa, pero yo no lo he bloqueado.
I have
Me
not blocked it.
baño, pues a dormir,
I
me levanto a trabajar todos los
I go
días.
to sleep. I wake up every day for work.
I'm sorry.
Anything.
I will tell you that I don't believe you.
No lo creo.
These devices are supposed to remain on your skin. The device remains in constant contact with your skin. And when it comes out of contact, and when it comes out of contact, it gives us an alert. And when it remains out of contact for a certain period of time, that's when we know from pre-trial where they tell us that it has not had a continual contact with you for however long it may be. That's why the first time was 11 hours, second time was 9 hours. I wasn't there. I have no idea. All I know is that it lost contact. And this doesn't magically appear like a fart in the wind. It has to be there from some purpose. It doesn't magically.
Those machines are not available. I've explained the situation before. I had the exact same situation in Court 8 where my client had Fram. She also had a portable device. In the exact same time frame, it says she had a .157.
Okay, so there you're dealing with a positive result versus here we have a tamper. Something different.
It may be different, but it just goes to the fact that they're not perfect.
Notice what's happening here. He keeps circling around the question instead of answering it directly. Judges hate that. And when you're dealing with tampering allegations, even dust from work, excuses won't cut it. What do you think? Is this guy buying time, or are these devices just too unreliable?
It's not perfect science behind myself.
I have hundreds of other people.
Notice what's happening here. He keeps circling around the question instead of answering it directly. Judges hate that. And when you're dealing with tampering allegations, even dust or work excuses won't cut it. What do you think? Is this guy buying time, or is the device just faulty?
On these devices, and they have never had any issues. You know?
Lo tengo un poquito flojo, eso sí, que eso fue cuando me lo pusieron para atrás.
It was
No lo he tocado.
that's the only thing, but I haven't. Like it was from the beginning.
Now it's flojo.
No,
Judge, he's not changing the story. The original question was what happened. He's explaining exactly what happened. He's explaining what happened. The specific question was whether he put anything in there. He's saying, I did not put anything in there. He already knows that you told me, tell me the truth. Things gonna be fine, and so there's no reason for him to lie about that. I've talked to him 4 times now, and he's always said, no, I don't know what it is. Maybe it's affordable. I don't know what it is, but you know, that's what he said. It's wet in there, and I used a blower on it. It's like, I don't know. I mean, what if we also have him do the portal? I mean, I don't know what to tell you, Judge. I'm trying to remember why we ended up getting why he had to scramble for his position. I don't remember the case.
I mean, I'm not going back onto why. I mean, I'm ready to just revoke his bond because he's not.
I understand, Judge, but he didn't test positive for alcohol. He's never had a bond violation before. When I told him he had to come to court because of a bond violation, he was here at 8:40. So it's not like he's hiding from anything. I'm in constant contact with him. I think I would appreciate it if we could just keep going and see how we can resolve this case, Judge. Again, tested negative for alcohol and drugs.
State, what do you think?
Judge, I mean, I just think it's important to know that you already know. There's been 2 tampers. One occurred at 3 o'clock in the morning. Also need information. I'm not sure what hours it will work, and I understand we'll have to occur over time. But I don't know. I do see that he also, I think there might have been something about the prior DWI in Tarrant County as well. I'm seeing that on the history, but I'm looking into it right now. I don't want to formally say that he's
which may have been the reason why.
That could have been the reason why it's in the first place.
How long ago was that?
It's like 2019. If I run his NCIC, I'm not seeing it condition, right?
The thing is,
That's from 2019 Tarrant County, Judge, so we don't know what's going on with it.
what I'm going to do now is I'm going to alter and amend your conditions to give you a curfew. I don't want you out in the middle of the night. And I'm going to tell you, if you ever have another violation with me again, I don't give a rat's behind what your excuse is. I will put you in lockup. I don't care what you're doing. I don't care where you're going. I don't care what your excuse means absolutely nothing to me. I don't care about excuses. I care about actions. You either make the correct action or you make the wrong action. And when you have the wrong action, there are consequences for those actions. You're old enough to know about this. So I am now giving you a curfew of 9 p.m. to 6 a.m. You go out past that time, then I'm going to put you in lockup. And I don't care what you say. I don't care what you're doing. You understand? That's it. One more violation will stay with me. If you need to go get that machine changed out today, do whatever you need to do. Because I will not entertain any more excuses. And because with tampers at 3 in the morning, who knows what is going on, but nothing good happens at that time, and that's what scares me. If you're out and about and you're tampering with that time, something no good has happened. You will not get any more benefits of the doubt. All right. That's it. Hey, no tolerance.
Yeah, what? He has a GPS as well. His GPS and
Curfew on him now because I don't think he doesn't have a curfew now. It goes on now. All right.
Yeah.
What is it?
It's been no violation. Right.
So he has a curfew. Where was the tamper at 3 a.m? Can you tell me? Take your time. Get the coordinates. I'd like to know if he's at home. All right. If he's out and about, I'm gonna have an issue with it. Look into it, and then I'll.
What's the answer?
You know how many muck-ups we have there? Never take anything for granted. Never take anybody's word until you look into it. Never. Until you do it and you can 100% confirm yourself. So please look into it. I'll give you a normal reset for now. But now the curfew is now and anymore. That's it.
So
I don't know, and it was never mentioned. And I didn't even.
Wait, I guess it wasn't mentioned because there was no violation on it, but we'll find out.
All right.
Thank you, Judge.
Joe. Come up.
Well, this is very valid explanations people want to hear. The situation, it's a very unusual situation.
What time does court start? Mr. What time did you get here?
I didn't have to come today. After the 4th, I was supposed to communicate with my lawyer.
I ordered you to come here today because you have a new case. You are on bond for an assault. You now have picked up a new assault. You are now facing another year and
And there it is. Blood on the car window. That's hard evidence. Forget that he said, she said. Physical proof like this can instantly tip a judge toward probable cause. In court, marks and injuries often speak louder than words.
Or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed.
Defendant and the defendant relationship. 11/27/24, officers were dispatched to an assault in progress in Harris County, Texas. Officer met with other officers who had already detained the defendant. The officer spoke to the complaining witness and she felt pain. She stated that they had been driving down Westheimer and the defendant suspected the case for hers that had a flash drive that had fraudulent scam material on it. Complaining witness said the defendant was trying to scam San Jose Gas Oil and the information was on the USB drive. Complainant stated that they started to fight and she scraped her hand on the first and felt pain. Complaining witness also stated no threats were made and the suspect did not put his hands on her. Defendant stated they were arguing in the car and complaining witness slapped him twice and scratched him. Defendant stated he felt pain.
Are we supposed to be impressed that he's supporting kids while out on bond? Reality check. Responsibility at home doesn't erase responsibility in court. Judges usually hear these hardship pleas every day. But does it really outweigh repeat violence?
The witness stated she worked security and she saw the traffic was backed up, so she drove up and saw the complaining witness and defendant and stopped the car in the street. She said she saw the complainant and the defendant fighting. The complaining witness was trying to exit the vehicle and actually the vehicle from fear. Witness stated the complainant exited and ran across the street and called 911. Officers observed blood on passenger window where complaining witness was. Officers also observed complaining witness have injuries to her.
Your Honor, no, the one thing I just wanted to point out was more on the dates, in that apparently he thought that the new case was set for December 5th. This document, this is referred to December 5th. Down bottom, it looks like then it was ordered that he appear at the court's next docket on Wednesday, December 4th, because the original case that we had been here for, the first case, his appearance was waived on that case. So he got confused and thought it was waived, and I think
We wanted him to appear because of the new case that we have. So regardless whether he comes at 8:30, he comes at 9:30, I don't think I've ever taken someone in for coming in at 11:30, coming in at 12. But I do have a problem when you pick the new case.
yes, sir.
And it's alleged here that you have assaulted this person, and they have now provided me with enough evidence that I'm going to find probable cause that it occurred. Joe?
So, Your Honor, the only thing I can say is, the client has vigorous defenses. Obviously, that's not the appropriate point to point out. But, I don't know, was the complaining witness out on probation at this time, or she herself was under, legal?
All I know is that
Very
it's 2 times that he pulled her hair, or was it just 1 time? Sounded like it was.
He was trying to prevent her from, she was gonna go out to the moving vehicle. He was trying to get her, from going out to the moving vehicle.
I didn't hear anything about that.
I believe what happened is she called and reported this afterwards. They left the scene and then she called the phone and reported that.
So is she trying to jump out of a moving car and he's pulling her hair to keep her in? Well, but then the witness sees them outside of the car arguing, and then he pulls her hair outside of the car.
I heard that. I did hear that.
So the witness saw the defendant and the complaining witness inside the vehicle fighting. The witness tried to get the complaining witness out of the motor vehicle, and then the defendant
Pick up
pulled
the
her
case.
back.
Like, are we supposed to be happy you're on bond for an assault? And you pick up a new assault. Well, now is, I mean,
Somebody that was.
Por favor, me refiero que diga que soy allá. Ella es mi novia y ahora mismo está en la prisión.
She's my girlfriend. She's right now in
Porque ella está diciendo una cosa.
she's probably
Yo quiero que ella lo
okay,
Yo soy la
you,
The only reason that was relevant, Your Honor, if I can help him out, is that he did tell me beforehand to help the court and the system, is that she has been his girlfriend for many years, and that he has one child he supports along with his mother, who's here today, and he works as a driver, and he does support them all. But she does have this problem with drugs and has this pending case. He himself suffers from depression and diabetes, but he does manage to work in order to support them all. These are just things that maybe the court would consider, because it would be a real hardship for them to lose the income. Now, he would agree to any kind of additional controls in terms of staying
And
away
now
from
the
her.
twist. Both the defendant and the alleged victim might have been arrested around the same time. Messy, right? When both parties have charges, it muddies the waters. But here's the kicker. The judge still has to decide if this guy is safe enough to stay out, or if lockup is the only option.